Hi contract students, Professor Orenberg here, and today I have a special Halloween edition for you to discuss one of the vexatious topics in contract law, the Parol Evidence Rule. The Parol Evidence Rule seems to confuse students, and I think it's because the restatement and the UCC use different language, and quite frankly, the whole thing doesn't have to be so confusing. So if you'll bear with me for about a 10-minute video, maybe by the end, I'm going to make this simple for you using a Halloween example, candy. There are effectively three types of contracts under the Parol Evidence Rules analysis, and we're going to call them drafts, final documents, final contracts, and then complete or complete and exclusive agreements. First off, to discuss drafts. Drafts are not contracts, as evidenced by this empty jar here. Sure, there may be ideas and preliminary negotiations that go into a draft, but the question of whether something is a draft or whether it's final is not a contract interpretation question. It's a contract formation question. You see, a draft is an unformed contract. In other words, it's not a contract. It doesn't have sufficient terms. It hasn't been established with enough certainty, and the parties haven't completed their preliminary negotiations, all of which are not contract interpretation topics. Those are contract formation topics, which hopefully you have learned in previous videos or classes, but feel free to refer to my other videos on contract formation, because the difference between something draft and something final is whether there's been a manifestation of mutual assent to the terms. So let's set draft aside, because that's not a contract. The real work that we need to do is to compare something which is final to compare something which is complete. What's the difference? Well, something final is a contract, and it means that the parties have agreed upon certain terms. And they're represented here by a variety of colors or flavors of airheads. We've got a bunch of watermelon and this white mystery flavor. So the parties have agreed to have these terms in their contract. And on a handshake or signature, or in this case with a writing, probably both, a signature, they've decided that these terms they've agreed to. They've written them down, and in the writing itself we have these 5 terms. And now we know that these terms are binding, right? So if we pull out one, say, oh, am I obligated to sell the car for $20,000? Well, if it's a written term in the contract, yeah, that's an obligation. Am I obligated to have gas in the car at the time of sale? Yeah. Am I obligated to have the car inspected at the time before it's sold and have it pass inspection? Sure, that's a term that we have in our contract, and those terms are going to be binding. That's what makes a contract binding. So what can and can't we do with a final agreement? Well, we can't change the terms. So for example, if we have a term in here, we're going to use white mystery to represent price. Mystery probably is a bad representation of price. We should know the price. But let's say that we have agreed upon a price term of $20,000. And a party says, but before the contract, you told me that if it was Thursday, or if I paid in cash, you would sell it for $15,000. The party is trying to offer evidence of a preliminary negotiation, but not just any preliminary negotiation, one that would change a term that is already in the final agreement, right? We have a discrepancy. $15,000 and $20,000 are not the same. They both regard price, $15,000 for the price, $20,000 for the price. We already have a price term in the final contract. What does final mean? Final means, by definition, something that isn't changing. These terms can't change. So I can't change white mystery into cherry. I like strawberry better, but this one's cherry. Anyway, we can't change the term. That's not permitted under the Parol Evidence Rule. At least I can't offer evidence that prior negotiations changed that term. We can talk later about subsequent modifications to a contract. We do have some separate rules around that. But again, sticking with the Parol Evidence Rule, what does it mean? Final means unchanging. It means we're not going to change it. The terms in this contract are final, and so we can't directly change them. I can't take out the $20,000 price term and put in a $15,000 price term. I can't use preliminary negotiation evidence. I can't say that we agreed on that previously and it's going to change the writing. All right, so let's reset our contract. What can we do? We can add terms. Maybe there are things that we haven't discussed yet. Hey, that fuzzy dice in the mirror that I really like, will you include the fuzzy dice as represented by Haribo gummy bears? The best gummy bears, by the way. Well, we can add a term to a final agreement. That isn't changing it. Notice I didn't change any of the airheads in there. The price airhead is still there. The deliver it with gas airhead is still there. The passing inspection airhead is still there. None of those have changed, and none of those are directly impacted by leave the fuzzy dice in the mirror gummy bears. We can put that in there as well. Now, I'm not saying we do. I'm saying we can offer evidence that the parties agreed to sell the car with the dice in the mirror. All right, the question is only, can I even offer evidence that would add a term? So that's the difference between changing a term and adding a term. It depends on whether or not there's already a term in there that speaks to that point. Right? We already had a price term. A different price term would change the price, change the term. Whereas we didn't have a fuzzy dice term, so we could potentially enter evidence that would add that term. Now, let's move on then to a complete agreement. It's represented here by this jar of Starburst with a lid on it. A complete agreement is one that says, in its own terms, usually there's something called an integration clause or a merger clause, this contract is complete and final and is the exclusive statement of the parties' intentions regarding the subject matter herein. It will tell you that, right? It will have a lid on it. It will be visibly complete. How is complete different than final? Well, complete can't be added to. That's what complete means, right? If something's complete, you can't add to it. It's full. In fact, I've really tried to represent that by having a full jar of candy here. Right? I wouldn't be able to jam another airhead in here if I wanted to. So long as something is within the scope, right? Within the scope of this complete agreement, it can't be added. This contract is not only final, but it's been completed. It is not susceptible to additional terms. And once again, how do we know that? Well, in the case of the jar, it has a lid on it. Right? You go to the store and it's sealed. Right? You know that nothing else is going in there. In the case of a contract, it will have a term. It will say something like, this contract is the complete and exclusive statement of the parties' agreement with relation to the subject matter hereto, or something like that. So again, the difference between a final contract and a complete contract is the complete contract will tell you that it cannot be added to. Something that is final, you can add to it. You can at least submit evidence that there should be something added. You can't change a term. Well, if you could, it wouldn't be final, right? Think about it. That's what final means. Final means not changing. You can add. You just cannot change. So we can't change out the price term for a different price term. That's not permitted. But we can add our fuzzy dice term and make that part of the contract if we have evidence offered properly. All right, so hopefully that helped you understand the Parol Evidence Rule. We have other terms in the Restatement of Contracts, just for your edification. When we talk about, well, draft is draft. Again, draft is not a contract, so don't worry about it. A draft is something that you'll deal with in contract formation, so forget about it. Final is often referred to as a partial integration. Partial meaning the terms in there are for reals, and they're going to stick, but there might be others. It is not complete. Whereas something complete and exclusive, it's a complete integration. There's nothing else that can go in this jar. The only thing we have to establish is what is the scope of this contract, right? So this contract pertaining to a car may not pertain to asphalt paving services and something like that. So there are things that are outside of the scope, and they just represent a different contract. But for our purposes today, I hope this video helped you understand the Parol Evidence Rule. And happy Halloween.